Yes, sir.
What time did you wake up today?
I woke up at 10 o'clock with Teddy banging on my door, telling me this whole story. Cause I went to sleep, said good night, babe, I love you, I'll see you in a little bit. Cause she said she was gonna come sleep.
And what story did he tell you?
What's that?
What story did he tell you?
Jordan's last party. On August 2nd, 2014, 20-year-old Jeffrey Rushing attended an after party with many of his friends, including a beautiful young lady named Jordan Nedeau. That was Jordan's last party. She ended up dead in the early morning hours in a vehicle that became submerged in a river off Tower Road in Tallahassee. The driver was Jeffrey, but unlike Jordan, he managed to get out. There are many similarities between this case and the case involving the death of Mary Jo Kopechny, including that the two men involved in separate tragic car accidents years apart were known as Teddy. 55 years ago, on July 18, 1969, Ted Kennedy crashed his vehicle off a narrow, dangerous bridge within the small Massachusetts island of Chappaquiddick. The vehicle became submerged in the water, but Ted Kennedy, who was driving the vehicle, managed to get out. Sadly, he had a passenger with him, Mary Jo, who was unable to escape and perished in the vehicle. Sadly, the case was not properly investigated. Ted Kennedy got a sweet deal by taking a plea to leaving the scene of an accident with injury and received a small suspended sentence. The lack of a full criminal investigation left a lot of questions unanswered, so justice was never done in that case. Jordan's case has many similarities, but one huge difference. Jeffrey Rushing was charged with DUI manslaughter, vehicular homicide, and leaving the scene of an accident resulting in death. The case was fully investigated and culminated in a trial, pitting prosecutors Georgia Cappleman and Sarah Dugan against seasoned criminal defense attorney Tim Jansen, with Judge Terry Lewis presiding.
Did you come up with anything?
Yes, sir. I pulled some case law. May I approach?
Mm-hmm.
I've already given a defense a copy. So the first case that I gave to the court this morning was State versus Lewick. It's a 4th DCA case. Basically just outlines the requirements of reckless driving. It has to be willful and wanton, has to be intentional. The defendant has to have conscious and intentional indifference to the consequences. And the question is whether the defendant could reasonably foresee that if he knowingly drove his vehicle in such a manner, and under the conditions that he did, that he would likely cause death or great bodily harm. In the Lewick case, the defendant was driving on a bright, clear morning at about 8:30 a.m. The car the defendant was driving had shallow tire tread, a missing lug nut, and window tint that was too dark on the bottom part, I guess, of the windshield. The speed limit on that road was 45. The defendant was initially going about 60. The speed at the time of impact was about 48, just 3 miles per hour over the speed limit. The defendant approached an intersection. He didn't slow down. He ignored the traffic light that was at that intersection, even though the traffic light had been red for about 5 seconds, and he hit an oncoming car. The court found that he drove recklessly in that case, and in that case, the defendant was only going slightly over the speed limit, but he ignored road signs, he ignored the traffic light. There were other factors going on with the car that could have caused him to reasonably foresee that driving in those conditions could cause a crash that would cause great bodily harm. Tint that was too dark on your window or on your windshield, a missing lug nut, shallow tire tread, you're not able to brake as well. Woodard versus State, which is the second case that I gave the court this morning, is an appeal to the 9th Circuit Court from a county court in Orange County. And in that case, the court found that there was reckless driving where a car accelerated through a stop sign, there were acceleration marks before the collision, and the witnesses described the defendant at the scene as being pretty messed up, as in intoxicated. That case cites to McCreary versus State, which is the third case that I provided the court. Woodard kind of summarizes McCreary.
Can I back you up a second? What was the ruling in this case, the Woodard case?
That was sufficient to be reckless driving.
Okay.
And in that case, again, we have the driver ignoring a traffic sign, ignoring a stop sign, going through it, and his intoxication came into play. What the witnesses at the scene recognized the defendant as being messed up. So McCreary versus State, which is the third case that I've given the court this morning, is a Supreme Court case. In McCreary, the Supreme Court held that a car that went through a stop sign, and the stop sign could be clearly seen at about 400 feet ahead of it. The traffic was heavy that day. They noticed that the defendant had alcohol in his system immediately prior to the incident. The defendant drove through the intersection at the speed limit without slowing down and caused a crash which killed the driver. And again, in that case, we have somebody going about the speed limit but ignoring a traffic sign and causing a crash and having alcohol in his system. And the court said that that was reckless driving as well. In this case, I think when you look at a totality of the circumstances that we actually have way more factors than any of the cases that I provided the court. In this case we have here today, the defendant was driving at 6 a.m. after been up partying all night long. I think he said that he went over to his friend's house the day before at 3 p.m. So he's been up partying since 3 p.m. the day before, almost 24 hours. He said that he'd consumed 14 beers throughout the night, Xanax, cocaine, and marijuana. He was driving without a seatbelt on. The passenger in his car was also not wearing a seatbelt. She was also intoxicated. He's driving with no headlights on. He's driving on a country dirt road in an area that he's not familiar with. He had been on all paved roads. He drives past a pavement in sign, continues onto the dirt road with no idea where he's going, which should have been the first sign that he should have turned around. But he doesn't. He doesn't turn around or stop when he hits the dirt. He then drives past a dead end sign, ignores that, and doesn't turn around or stop as a sober driver would. He keeps going. He drives down a boat ramp and he crashes his car into the water. And he could have reasonably foreseen that driving when, you've been up partying for almost 24 hours. I don't even know when the last time he slept was, but partying for almost 24 hours. 14 beers, Xanax, cocaine, marijuana, no seatbelt, no headlights, passenger no seatbelt, passenger intoxicated, and is the person who's telling him where to go. Not familiar with the area, ignoring road signs. He's on a dirt road that's a dead end, and he keeps going. That all of those things that he's doing could have resulted in a crash, which could have resulted in great bodily harm or death. And he was indifferent to the consequences. So I think when you compare our case to the cases that I've given the court today, even though they're not, it's hard to find something that's exactly spot on every fact, but it's people that are, in a totality of the circumstances, are indifferent to the consequences of what they're doing. And they know that looking at the condition of their car, ignoring a road sign, going a little bit over the speed limit and not braking in time, those are things that can cause a crash, that can cause great bodily harm.
First, to kind of go distinguish these three cases. And really what we think the key is, all of these cases show an intentional act. What you've got on Lewick is rush hour traffic as compared to the exact opposite, a dirt road where no one is around. Missing lug nuts, shallow tire tread, dark window tinting, all things that they're basically showing there that the car was not in a proper manner to drive safely in the first place, that they were knowingly driving a dangerous vehicle. There's zero evidence as to the condition of the car in this case being anything problematic. There's no argument that he was knowingly driving a vehicle with problems. The state says slightly over the speed limit. They were actually driving 33% over the speed limit. I don't think that's slightly in any court that deals with speeding tickets on any day. Most importantly, they noted that the traffic light had been red for 5 seconds and the defendant, Lewick, accelerated through the intersection. There was a red light telling him to stop. The reason they noted it was red for 5 seconds is because they wanted to show that the defendant knew or should have seen that light at that time and intentionally accelerated through. I don't believe that without accelerated through, they would have had it in this case. You go on to McCrary. They actually did a list of what they found on page 4 of 7. The intersection was a safe intersection which meets all applicable federal and safety regulations. There is no evidence in this case that the area where the crash occurred was a safe intersection. We would argue there's actually evidence that it's an unsafe intersection. And even more by that, the subsequent remedial measures the city took by adding extra signs and moving the signs closer to the roadway. Again, you have heavy traffic. It says the traffic through the intersection was heavy. That's the exact opposite of what we have here of a dirt road with no traffic. The intersection stop sign can be clearly seen from 400 feet. Had the state attorney gone out 100, 200, 300, 400 feet and taken photographs of where the sign was located at the time of this night and shown that you could clearly see all of these signs and they were not tucked back in the woods like we would argue, and we'd ask the court to look at the pictures there, they would have a better argument. But here you have heavy traffic in intersection, one that's regulated, that it meets all safety requirements, and from 400 feet away that he went through without reducing speed, did not apply brakes, and had enough force to knock the driver. And again, in this case, there was alcohol. But what we would say here is that you've got heavy traffic and a safe intersection, and that for somebody to be driving in that area with those conditions, that's where your recklessness comes from there. And then when you look at the circuit court case from the Ninth Circuit, this would be the Woodard. What we would note most important here is they did a crash reconstruction. They had an expert come in and testify that Walker determined that the defendant's car made acceleration marks on the roadway from a point prior to where the collision occurred until almost where the car's final resting place. And most significantly, they made a note that the driver's license was suspended. So this is an individual that for one reason or another was not supposed to be driving an automobile in the first place. There's no evidence that the defendant's driver's license in this case was anything but valid. But again, you've got a court noting that acceleration marks on the roadway from a point prior to the collision. And that's our positions. The big difference between careless and reckless in all of these cases is the intentional acceleration through safe intersections where there is heavy traffic. What you've got in this case is a passenger who was dropped off and said it was becoming light out. A car that may or may not have had its headlights on, but it may or may not have been light out. There's no evidence that the headlight switch being the off position, if that, assuming for argument, is that the headlights were off at the time, that it was anything but light out. Yesterday, they just argued through their experts that it was between 5 and 7 a.m. because no one really knows. Today, when they're arguing the JOA, they say 5 a.m. Our position would be that if the passenger was dropped off and said it was becoming light out, and at some point later the crash occurred, there's no evidence that the lights need to be turned on. There's no evidence of any speeding. There's really no evidence of anything that would be a civil traffic citation in this case prior to the final resting place of the vehicle, the final careless driving going into the lake. We would also note, we think the most important thing in this case is there's direct testimony before the court that whatever state the defendant was in and whatever mental state he was in about his driving that day, there was a passenger in his vehicle prior to the crash who testified that he was able to navigate Capitol Circle and all these other much more serious roads without any problems. Had this crash occurred at a regulated safe intersection on Capitol Circle, it would be McCrary. Had they done a crash reconstruction that showed he accelerated past these signs into the lake, you might have one of the other two cases. But our position would be with the lack of any acceleration, with it being an unsafe intersection in the first place, with the headlights are not being meaningless because the light's on, and with the last witness to see the driving having no problems, not even feeling the defendant was impaired, and that was a witness called by the state. Our position is there's no evidence where a jury could lawfully find that he had the willful, intentional, wanton disregard for public safety when he lawfully drove a lawfully safe vehicle in this case, and we just have concern that there may be enough jury appeal due to the tragedy of this case that he could be convicted by a jury even though it would not sustain the requirements.
I'm going to deny the motion. I was inclined to grant it, but I think it's close enough, given what I see in these cases, to justify it going to the jury, let them decide. So I'm back. I guess I need to add one little thing then I had to the jury instructions. Let me pull those back up.
Here's the horn of this. I'll just make a little note. You can pull on and just, you'll know when it's out there. So 42, 41, job. And then that one should kind of zoom in there.
Voluntary intoxication is not an offense to a crime. May not be taken to show that he lacked a specific intent. That's what the state wanted, and it sounds like it might be appropriate. So let me take that out. Okay. Other than that one, we were okay on all the lesser included yesterday. Did y'all look at the verdict form of the state?
I'm sorry, Judge.
I was asking if they looked at the verdict form you provided.
Your Honor, before we go forward on the verdict form, in looking at the instructions that you forwarded me last night, and I know I may change today, I get the page 2, the bottom of it, and it says you find them guilty if you find of influence of manslaughter. You further find beyond reasonable doubt that, and then there's a paren 4 that shows up on the top of page 3, and it's talking about leaving the scene. And I don't know.
Sorry.
And
I agree, Judge, that needs to come out.
Okay. What about the rest of that? Florida law requires, et cetera, et cetera. Because that all relates to,
That relates to the leaving the scene. I don't think any of that should be in that position.
whether,
Right. My intention was to charge those counts separately, so I don't
Okay.
get into a double jeopardy issue.
all right. So I'll take out all that, good. This makes it shorter. Do I leave in normal faculties? Yeah.
Yes.
Okay. All right. Anything else you see?
Well, I think then that all that language has to go back in where the leaving the scene of the crash is involved on page 4. Correct? Am I wrong, Judge?
I don't know,
What's the question?
but I just cut all that. I could have.
Well, I see paragraph on page 4. It says,
Should I put that same language in? I mean, the leaving the scene is, I think, the standard. Look at the standard and see if it's different.
I don't think that'll be a lesser of the vehicular homicide or the manslaughter.
No, it's not a lesser, but I mean, he's talking about the main elements on
Count 3.
leaving the scene of an
on
accident.
count 3, right.
Yeah. Whatever standard is not objectionable.
Look at the standard and see if it's different.
Okay.
Because I think that was, what Laura did was what is generally the standard.
Count, Tim.
But I'm going to go back a second and recover that just in case.
Leaving a scene, and he wants to know if there's additional evidence that needs to be included.
Anybody know what number that is?
28.4.
28,
28.4?
transportation offenses?
Yeah. Yes, sir. 28.4. Just see what's in there. What they're asking
Here's the standard,
for
Tim.
is the leaving a scene language that is originally part of count one. See if that judge is corrected. So they're asking that all that stuff that just got cut out of count one, stuck in count three.
Yeah, I'm looking at the standard, and it doesn't have all that extra stuff. It just says identifying information means yeah, the language that's in count one that you don't want in count one is what's used if you're enhancing that one with failing to leave or leaving the scene of the crash. The state said they charged it separately, so I guess that should come out.
Yeah. I think what maybe needs to happen is because she's doing it, the state's doing that unique way of charging count two, that maybe we need to take the language from the enhancement of count one that talks about the leaving and failing to give aid and add it to the count two.
Vehicular homicide?
Or count three, I'm sorry.
But count three is, what you see is what's the standard jury instruction for count three. So it would seem redundant. All this is an explanation, a longer explanation of what's required under.
Doesn't the standard for count three not even mention the theory that they're going on, this failure to report to a duly authorized police officer? Did we have to add that the other day?
Well, let me look at count three.
Yeah, I think the standard doesn't cover their theory, was our issue the other
No, it
day.
says he failed to report the crash or he willfully failed to render assistance. That's what it says.
Or duly authorized, failed to report the crash to the nearest office of a duly authorized police authority.
Right.
That's what the state actually charged him with in this case, via the information. I don't
Did-
see that mentioned in the standard instruction anywhere.
Number 4?
Well, it's in the instruction though that I've got.
Number 4, parenting number 4.
Yes.
Yeah, so we added that to the standards. That is, if they had charged the DUI and wrapped the leaving into it, this is the instruction that's given.
That is already there.
No,
Yeah.
Yeah, the language that's being taken out of count one is a verbose, long-winded explanation of what kind of information you're supposed to give and what reasonable assistance means. And so I think you got that covered adequately.
we don't see anything under the.
Yes.
Judge, on the defense would request that the long language be added to count 3.
Not going to do that. Anything else you want?
Read the language you want into the record.
Okay. Judge, for the appellate record, I want to put on the record the language we want to put in, which starts on page 3 of the proposed jury instruction. And it gives a long, detailed version of what the law requires for the enhancement, but it gives a more descriptive. Florida law requires a driver of a vehicle involved in a crash resulting in injury to or death of any person or damage to any vehicle or other property which is driven or tended by any person must supply his name, address, registration number of the vehicle he is driving to any person injured in the crash or to the driver or occupant or person attending any vehicle or other property damaged in the crash. Upon request, and if available, the driver shall also exhibit a license or permit to drive. The driver shall give the same information and upon request exhibit his or her license or permit to any police officer who is at the scene of the crash or who is investigating the crash. The driver shall also render reasonable assistance to any person injured in the crash, including carrying or making the arrangements for carrying of such person to a physician, surgeon, or hospital for medical or surgical treatment if it's apparent that treatment is necessary or if such caring is requested by the injured person. In the event none of the persons specified are in condition to receive the information to which they otherwise would be entitled, and no police officer is present, the driver of the vehicle involved in the crash, after trying to fulfill the requirements listed above as much as possible, shall immediately report the crash to the nearest office of the duly authorized police authority and supply the information specified above. Normal faculties include, but are not limited to, the ability to see, hear, walk, talk, judge distances, drive automobile, make judgments.
That part's in the
That's
jury
it.
now.
Okay.
Let's see about stuff that's not in. Otherwise, everybody okay?
Yes, sir.
So, otherwise, everything all right?
I think so, Your Honor, on the proposed instructions.
Okay. Well, I'm going to get some copies in, and we'll come back and have closing arguments. Mr. Najur?
Ms. Anderson, I'm gonna put that down the check, but the rest of them are in there.
Well, I did tell them 8:30, and it's just now 8:30. Yeah, well, yeah, no, but, yeah, they should be here. 8:30 is when we're going to start. Yeah. They can sit and rent them out. Okay, I sent that to Laura, and I'm gonna go get those. Pardon? Oh, no, I'll get them. I just sent an email saying. Yeah.
Looking from the passenger side. What number is that? Maybe, gosh, I don't know. Did they renumber them? No. It should be 10. I'll do this one. Yeah, let me see if bring the ones that I think that's really weird. It's not all that This is 42. Mm-hmm. 41. Yeah. Yeah. Those are the only things I was going to do besides the map. So I'll just hold that one. So let's just go ahead and put it right here. Just so I'll cover this, although I won't.
We're back in session.
Have a seat. I'll let you distribute some for lawyers and court reporter and juries.
We like actually do those right now.
We were short one?
I'll say these are the two.
Oh, well. Okay. Well, let's bring them in. We'll get started. All right, record reflect all the jurors are back and the defendant is present, and welcome back, folks. And after that short work day, I'm sure you're all rested after that long night, but we're ready to start with our closing arguments. In the final jury instructions, as promised, I provided a copy of the jury instructions to you. And what I do on jury instructions is I read through them until I get to the part that talks about closing argument. Then I turn it over to lawyers, let them make their presentation. I come back and finish up with the closing arguments. You're welcome to read along with me as I go through. You're not required to, but you're welcome to if that helps you. And so I will begin those now. Members of the jury, you've listened attentively to the evidence presented in this case, and I ask that you now give careful attention to these instructions on the law, which I'm required to give you and which you are required to follow in order to return a lawful verdict. The defendant in this case has been charged with 3 different offenses, which we call counts. Count 1, manslaughter by driving under the influence. Count 2, vehicular homicide. And count 3, leaving the scene of a crash involving death. To these charges, the defendant has entered a plea of not guilty. This means that you must presume or believe that the defendant is innocent. This presumption stays with the defendant through each stage of the trial, unless it is overcome by the evidence to the exclusion of and beyond every reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crimes with which the defendant is charged were committed and that the defendant is the person who committed the crimes. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction that is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt. You must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. To prove the crime of driving under the influence, manslaughter, the state must prove the following 3 elements beyond a reasonable doubt. 1, Jeffrey Rushing drove or was in actual physical control of a vehicle. 2, while driving or in actual physical control of the vehicle, Jeffrey Rushing was under the influence of alcoholic beverages or chemical or controlled substance or a combination thereof to the extent that his normal faculties were impaired. 3, as a result of operating the vehicle, Jeffrey Rushing caused or contributed to causing, so a little grammatical, I don't think you need that extra, contributed to causing the death of Jordan Nedeau. The court instructs you that cannabis, cocaine, and Xanax are chemical or controlled substances. Normal faculties include, but are not limited to, the ability to see, hear, walk, talk, judge distances, drive automobiles, make judgments, act in emergencies, and in general, to normally perform the many mental and physical acts of our daily lives. To prove the crime of vehicular homicide, the state must prove the following three elements beyond a reasonable doubt. 1, Jordan Nedeau is dead. 2, the death was caused by the operation of a motor vehicle by Jeffrey Rushing. 3, Jeffrey Rushing operated the motor vehicle in a reckless manner likely to cause the death of or great bodily harm to another person. The state does not have to prove the defendant intended to harm or injure anyone. However, the reckless operation of a motor vehicle requires the state to prove more than a failure to use ordinary care. A reckless manner means in willful or wanton disregard for the safety of persons or property. Willful means intentional, knowing, and purposeful. Wanton means with a conscious indifference to consequences and with the knowledge that damage is likely to be done to persons or property. To prove the crime of leaving the scene of a crash involving death, the state must prove the following 4 elements beyond a reasonable doubt. 1, Jeffrey Rushing was the driver of a vehicle involved in a crash or accident occurring on public or private property, resulting in death of any person. 2, Jeffrey Rushing knew that he was involved in a crash or accident. 3, Jeffrey Rushing knew or should have known from all the circumstances, including the nature of the crash or accident, of the injury to or death of the person. 4, Jeffrey Rushing willfully failed to report the crash to the nearest office of a duly authorized police authority, or Jeffrey Rushing willfully failed to render reasonable assistance to Jordan Nedeau if such treatment appeared to be necessary or was requested by her. If the state proves that the defendant willfully failed to give any part of the identifying information or willfully failed to give reasonable assistance, the state satisfies this element of the offense. Identifying information means the name, address, vehicle registration number, and if available and requested, the exhibition of the defendant's license or permit to drive. Reasonable assistance includes carrying or making arrangements to carry the injured person to a physician or hospital for medical treatment. Willfully means knowingly, intentionally, and purposely. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusations have not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition, well, it should be singular. The lesser crime indicated in the definition of manslaughter by driving under influence is driving under the influence. The lesser crimes indicated in the definition of vehicular homicide are, add a little R there, reckless driving and culpable negligence. For driving under the influence, before you can find the defendant guilty of driving under the influence, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jeffrey Rushing drove or was in actual physical control of a vehicle. 2, while driving or in actual physical control of the vehicle, he was under the influence of alcoholic beverages. And actually, I would add that same language, which is not there. Alcoholic beverages, chemical or controlled substances, or some combination thereof, to the extent that his normal faculties were impaired. So that takes you back. The missing part of that's in the initial number 2 under manslaughter by driving under influence. It's the same element. Okay. Normal faculties include but not limited to the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general to normally perform the many mental and physical acts of our daily lives. To prove the crime of reckless driving, the state must prove the following elements beyond a reasonable doubt. 1, Jeffrey Rushing drove a vehicle in Florida. 2, he did so with a willful or wanton disregard for the safety of persons or property. Willful means intentionally, knowingly, and purposely. Wanton means with a conscious and intentional indifference to consequences and with knowledge that damage is likely to be done to persons or property. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jeffrey Rushing exposed Jordan Nedeau to personal injury or inflicted actual personal injury on the victim. 2, he did so through culpable negligence. I will now define culpable negligence for you. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross or flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he lacked a specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. A separate crime is charged in each count of the charging document, and while they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and to know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and the other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Has any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony given in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, whether when the defendant made the statement he had been threatened in order to get him to make it, and two, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side has been given sufficient time to make a final presentation, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. So I'll turn it over then to Ms. Cappleman, I believe.
May I please support? Members of the jury, good morning. Thanks so much for coming back. The evidence in this case has shown that on August 1st, 2014, this defendant was out partying. And for him, a good time included 14 beers, 1 to 2 shots of liquor, Xanax, cocaine, and marijuana. And after making the choice to consume each and every one of those substances, he then made a choice to get behind the wheel of a car and drive. And by doing so, he chose to gamble with his own life, with the life of Jordan Nedeau, and with the lives of anyone out on the roadway that day. And it was this defendant that made that choice, this defendant that took that risk and that gamble, but it was Jordan and her family that lost everything that day. I have to prove to you DUI manslaughter, and to prove that, I have to prove that this defendant was under the influence of drugs or alcohol or some combination of each, to the extent that his normal faculties were impaired. Those kind of normal faculties that we need to operate a motor vehicle, the ability to see, judge distances, react to the circumstances and terrain around you. And what evidence do we have to prove the first part of that he was impaired? We have Skylar Smalley. She testified that everyone was drinking that night at the bar and at the after party, including this defendant. She also testified that when she came downstairs at about 4 a.m. at the after party, the victim and the defendant were in the kitchen drinking vodka. They had a bottle of Ciroc vodka, and we have a photograph from that night of the two of them with the bottle. Skylar Smalley testified that when she observed these two individuals in the kitchen, they were, quote, pretty drunk. And the defendant had at this point been drinking for about 7 hours, to her knowledge, from the time of going to the club to through the hours of the after party. We also have Ryan Degg. He also said that everyone at the party was drinking. There was marijuana being smoked at the party in the form of what he called dab hits, some type of oil form of marijuana. Deputy Bragg responded to the defendant lying in a ditch. That's evidence of intoxication. He indicated that the defendant did not appear to have any injuries, but did appear to be under the influence of something. Bragg gave him a courtesy transport back to the Golden Park address. Eventually, we have Deputy Davidson, and Deputy Davidson told you that the defendant walked into the sheriff's office on his own volition in the company of his mother and gave a statement. He had no signs of intoxication, no signs of injury, no signs of blackout, and he gave a statement to her that he had been intoxicated the night before. He even wrote the statement out. And in that statement, he used the word to describe himself, intoxicated. Detective Revel interviewed the defendant, and he made several more detailed statements about the substances that he had consumed in the hours leading up to the crash. And all of those statements are contained in State's Exhibit 38, those interviews. He talked about beer. He said he purchased an 18-pack of PBR beer that day and estimates that he consumed approximately 14 of those beers. And that brand of beer is corroborated by the fact that we have a PBR, or Pabst Blue Ribbon beer, shown in the vehicle after it's pulled out of the river. So that's evidence that corroborates his statement. Maybe he does remember things. Maybe he's not blacked out. He says he drank a few beers before the concert. He says he drank PBR, brand beer. He said he had one before the sound check, a couple more after the sound check, before going to the concert, and that he was still drinking at the after party. And he estimates a total of 14 beers that he consumed that night. He talks about liquor. He said he had one shot at the after party, but he later tells Dr. Pritchard that it may have been 2 shots, a shot of vodka and a shot of Fireball. He talks about Xanax, or the chemical name alprazolam. The defendant tells Detective Revel that he ingested Xanax at the club. In fact, he says, I wasn't drinking at the club because I was trying to be more responsible, so I just had a Xanax. He mentions 3 times in the interviews with Detective Revel that he took Xanax, and he even describes how that drug compounds the effects of the alcohol that he was also consuming that night. He talks about cocaine. He said he did 1 little line and 1 little bump. He did cocaine right after he got back to the house. So that's about, based on the timeline that he gives, 1-ish. And so if he consumed cocaine at that time, the expert testified that he would be in the crash phase of the cocaine. So he's not high or exuberant from it, but he's more in a depressive state at the time of the crash. Cannabis and marijuana. He talks about consuming marijuana as well. He said he smoked weed earlier before they went to atmosphere. So he mentions all of these specific drugs in the interview. He can tell you when in the night he consumed them, approximately. He can tell you how much. He can tell you what kind, what brand, whatever you want to know about his substances that he consumed that night. He's able to remember all those things. And as I mentioned, the expert, Stephanie Figueroa, told you that if he consumed all the substances that he said he consumed, along the time frame that he indicated, the results would be an impaired ability to see, to react to his surroundings, to multitask, and to perform the basic functions that one needs to successfully operate a motor vehicle. And even their expert, Dr. Pritchard, admitted that it would be a bad idea to drive a vehicle after consuming all those substances. What else do you have to indicate that he was intoxicated to the extent that he couldn't drive a car? Well, his normal faculties were obviously impaired because he drove his car off a boat ramp. So you have to consider his behavior, and this behavior is also going to be the basis for your vehicular homicide charge count 2. So his behavior is evidence that he was impaired. He took somebody home and doesn't recall doing it. You're hearing a lot about that throughout this trial as if it's something positive for the defense. He doesn't recall taking somebody home until he's prompted, and then he has one of those, oh, I was dancing on the bar moments, and remembers, oh yeah, that's why I was out by Tower Road. I took Ryan Degg home. Well, that's evidence of his intoxication. And ultimately, he drove down Tower Road at dark or first light. That's the evidence we have, with no headlights on. It's a dark area that's unfamiliar to him. He and his passenger, who is also intoxicated, are not wearing seat belts. They have no idea where they're going. They pass a sign that says the pavement is going to end, and it does. That does not alarm him in any way to stop, brake, where am I, turn around, nothing. He keeps going. 25 miles or 30 miles per hour, he estimates. Down a dirt road, unfamiliar, sees a dead end sign or doesn't see it, ignores it, or fails to observe it. That's an indicator of impairment. And then just drives right in the river. Those are indicators of impairment, and that's evidence of the reckless behavior that is required for the vehicular homicide count 2. So you've got everything that he consumed: beer, Xanax, liquor, cocaine, marijuana, no seat belts, no headlights, not familiar with the area, ignoring the signs, not stopping. So clearly he should not have been driving that night. So then the question becomes, was he driving? What's the evidence that he was driving? Is it a mystery that you guys need to solve? Whether he's driving or really it was Jordan that was driving? Well, what evidence do you have? It was his car, number one. Number two, Ryan Degg saw him driving, and he lives, 1 mile, less than a mile from where the crash occurred? That's where he got dropped off. And when he got dropped off, the defendant was driving. There was no conversation about his driving being terrible on the way to Ryan's. There was no conversation about switching drivers. There is no reason to think that they switched drivers. Number 4, he told Deputy Davidson that he was driving. He hadn't forgotten who was driving due to blackout. He remembered, and he told the deputy he was driving. He wasn't being interrogated. He wasn't under arrest. He was there of his own volition, accompanied by his mother, who apparently did not have reason to believe that he was suffering from a head injury or a blackout or was medically unfit to go up there and give statements to law enforcement. And he said he was driving that car and wrote it in a written statement. He also told Detective Revel that he was the driver. In both interviews that you have with Detective Revel, he talks about being the driver, he doesn't just say, I'm the driver. He gives specifics. I remember turning onto Old Bainbridge. She was telling me where to go. I remember Tower Road. I remember when it turned into dirt, and then, by God, that river just jumped right out in front of me. He says, I've never been down that road before. She done gave me directions, but she didn't say nothing about a lake coming up or slow down or nothing. So he was relying on his passenger to guide the vehicle or to give him instructions on how to drive this vehicle. Well, she was high and drunk. She told me to go right and go left, and then that's the end. I'm hitting the water. She was directing me where to go. I think I went right there, took a right out of Golden Park. I'm sure I was going probably about 25, I would say 30 maybe. Because this morning, more than anything, that dead end sign, I damn sure messed up. I remember turning onto Old Bainbridge. He even says he thought he was driving okay right up until the point he drove into the river. I mean, I wasn't drunk to the point where I was swerving all over the road or nothing. I mean, I was straight and in the lines. I mean, I remember that. From what I remember, I was driving fine. Right up until I drove into the river. The total times in that interview that he refers to himself being the driver, 10. That's just in the interview. Doesn't include Davidson, doesn't include his statements to Skylar Smalley. 10 times in those interviews with Revel. How many times does he say Jordan was the driver? 0. This trial is the first we're hearing of that. He wants you to ignore these statements because you have to. Either he wasn't drunk or he wasn't driving. Why would you ignore these statements? Because he was traumatized? Because he was intoxicated? Because being intoxicated, voluntary intoxication, as the judge read you, is not a defense. Even their expert told you, Dr. Pritchard, told you that you are most likely to get the truth in the first rendition. Skylar Smalley got the truth. Deputy Davidson got the truth. Detective Revel got the truth. He was the driver of that car. And he was messed up. He doesn't remember what state the windows were in. Does that mean he was blacked out? If the most truthful statement is the first statement, it's going to be those statements to Skylar Smalley. That's the first thing he said to anybody. And what did he say? Water. All I remember is water. And Jordan's gone. But he didn't tell the deputy that. He told Skylar that. He drove down Tower Road, and all he knew was he hit water. What else do you have to indicate that this defendant was the driver and not Jordan Nedeau? Dr. Flanagan says that Jordan's injuries are consistent with her being the passenger. Pat McLeod, the dive team guy, says when the vehicle was first raised to the point that he could peek in there and see her, her bottom half wasn't over the passenger seat. I mean, she was floating. She could have been everywhere in that vehicle. But when he first observed her, her bottom half was over the passenger seat, consistent with her being the passenger, and her torso was slumped over the console area. When she comes to final rest, yeah, right. Told her I was hiding it from myself. When she comes to final rest in this position, does that look like a driving position? I mean, even then, we're just going to say, oh, she's in the driver's seat. But the problem with that is she's not in a driving position, so there's no evidence that she was the driver of the vehicle. And Brian Pfeiffer, the accident reconstructionist, says that the seat position in the vehicle is more consistent with the defendant being the driver. Could she have driven? Yes, she could have driven that car. But it would not have been comfortable for her. She would have had to point her little toe to touch the gas. And the defense wants you to ignore all of this compelling evidence that he was the driver of that car. Because why? Because he doesn't remember he had his window rolled partially up. Because there's a crack in the windshield that proves nothing. She could have caused the crack in the windshield from the passenger side or the driver's side. Or it could have happened some other way in the wreck. I mean, this car was involved in a violent crash. It didn't hydroplane across a river. Anyone who's done a belly flop knows that water hurts. I mean, it doesn't hurt like a brick wall, but it hurts. And when that vehicle hit that water going 25 or 30 miles per hour, you better believe that there was a jolt. Loose items would be moving around the vehicle. Unrestrained occupants would be moving around that vehicle. And it's absolutely possible that she, from the passenger seat, impacted that window. It's possible that something else impacted that window and she hit the dash. But her injuries were not consistent with being the driver, because you would expect if she did hit the window and cause that injury from the driver's side, she would also have impacted the steering wheel, since it would be between her and the window. Is it possible that she could have flown over the steering wheel and just gotten her head? Sure, anything's possible. Is it reasonable? And is it reasonable in light of all the other evidence in the case? That's the question for you. And when you look at all the evidence in the case, you know he was the driver of that car. Finally, for the DUI manslaughter count, I have to prove that his driving caused or contributed to the death of Jordan Nedeau. And the evidence has shown that after suffering a bad bump on the head, she found herself disoriented and alone inside that vehicle. It's not so unreasonable that she couldn't make her way out of there. She was on all those substances. She had a bad bump to the head. it looks like she was looking in the mirror because the visor's down and the mirror's open. And she probably really didn't know what hit her. And all of a sudden, water is gushing into the vehicle. She obviously did not have the ability to save herself, as evidenced by the fact that she's not with us. And it is the state's position that this defendant did nothing to help her. And I expect the defense to get up here and tell you he did everything he could. He did nothing. And his own statement indicates that this young woman was calling out his name as that vehicle sank. He, the one person who had the ability to help her or get help for her, or at least try to get help for her, he failed. And she died in that river with his name on her lips, with water gushing in all those windows. You can't just swim out a window if it's like drinking from a fire hydrant with that water gushing in. She maybe went toward toward the driver's side where he was already out on the other side, trying to go out the way he went, trying to go to him, maybe trying to go away from the water. And he did not dive down there and try to pull her out. He doesn't know how he got out. He's 225 pounds, but he darn sure got out of there, didn't he? But he could not take her 90-pound frame with him. But okay, if he couldn't do it, if he was too high, too drunk, too pathetic to dive down there and pull her out of this vehicle, then get some help for her. Find somebody that can. And he was legally obligated at that time to render reasonable assistance. The defense wants you to believe that this man made reasonable efforts to get her help. The roof rack of that vehicle was only 12 inches under water. How about reach down in there and pull her out? All the other windows, besides the driver's window, were down. Go in one of those. Pull her out. Is she unconscious? Did she get a mouthful of water? Pull her out. But he left her there to die. And he didn't make any effort at that point to try to get her help. He could have and should have and was morally and legally obligated to stop at that first residence down the road and knock on that door, help, 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 I need help. What about the fire station? There was help there. He didn't get it. It's not a defense to be too high and too drunk to act reasonably toward other people. Each of us has a legal obligation to do that, and he had it too. And voluntarily getting drunk and high does not excuse you from that duty to others. Why didn't he get her help? One reason. Self-preservation. He was afraid of getting in trouble. He didn't want to get a DUI. Skylar Smalley confirms that. We knew what we had to do in the beginning. This is a quote from her testimony. We waited because he didn't want to get in trouble. He was reluctant because he didn't want to get in trouble. He was scared to call the police because he'd been drinking and driving. Well, that's not good enough. It's not good enough for Jordan Nedeau. He told you he ran until he couldn't run anymore. But make no mistake about it, he was not running to try to get help for her. He was running to try to save his own skin. He was running to try to distance himself from that scene. Are we to believe that he was too drunk or too high or too disoriented or concussed or blacked out to tell Deputy Bragg, if not someone sooner, hey, I drove my car into a river and there's a young lady that might still be in there, might be injured, might be hurt, might be dead. But he was well enough to run 2 or 3 miles from the boat ramp to where Deputy Bragg found him. He was oriented enough to recall seeing the Benson Heat and Air sign, but he wasn't well enough to knock on one of those doors and ask for help. He wasn't well enough to stop at the fire station and send help for the young woman drowning in his vehicle. But he was well enough to come up with a story for Deputy Bragg about how he came to be there in the condition that he was in, lying in a ditch without his car. He wasn't confused when he made those statements. He hadn't been separated from his friends the night before, and he hadn't had his car towed. He was trying to make up a reason why he was out there, because he didn't want to get in trouble. And this is the law, this is count 3. He was legally obligated to report the crash to the nearest office of a duly authorized police authority. Well, I think a cop in a uniform in a marked patrol vehicle talking to you and taking you home counts. And he ought to have said something to Deputy Bragg, and he knows that. He said he ought to have. He had no excuse for it. He wasn't confused when he was in Deputy Bragg's vehicle, and that's evidenced by the fact that as soon as he got home, he told Skylar Smalley. He collapsed in a puddle. He was freaking out because he knew he had done something bad. Number 1, please. His failure to save Jordan, or to at least try to send help for her, is a crime. And it's not lost on anyone in this courtroom that this defendant sitting over here is a young man. And this is a tragic case that has destroyed more than one family. But he is an adult, and he has to be responsible for his actions. And blaming the victim is not a very good start. All the evidence points to him. He's guilty of everything he's charged with, and as such, I implore each and every one of you to vote for a verdict of guilty as charged. Thank you.
Thank you. Mr. Jansen, you doing the closing?
Oh, yeah. Good morning, ladies and gentlemen. It's an easy case. He owned a car. He was seen driving the car earlier. And he made some rambling statements, inconsistent statements to the police that he thought he was driving. That's it. We spent 2 days. That's all we had. That's right. There's evidence. There's a burden. There's physical evidence. I didn't hear any of that. 0. We want to rely on statements from a bunch of drunk teenagers. Many of them were smoking, using drugs, passed out, don't recall. But that's how they prove impairment by other impaired people. Interesting. I told you in the opening that there is a mystery who the driver was. The injuries. How did the car and how did her body get out of the car? Who removed the car, the body? And what condition was that car in before anybody did any test on it? It could be sitting a Parkway towing company, a bunch of old guys out there selling parts, drinking beer, eating lunch in the car. We don't know. There's no evidence. how that car left the scene in the river. And then 10 months later, Dr. Pfeiffer, this high-priced guy, basically used a tape measure and got $10,000, whose figures weren't even accurate. How do we know that the guy that moved that car didn't get in there and adjust the seat? What contents were found in that car? Who was the investigator that investigated and said, I can't find DNA? Well, we know it wasn't Davidson. She's on duty and patrol. We know it's not Bragg. And we know it's not Bill Revel who said, I'm a homicide guy. Or no, he said, I'm a violent crimes investigator. I don't go do that. I basically took an interview. It's assigned, he said, to traffic homicide. Traffic homicide. I don't recall a traffic homicide investigator coming in here. Oh no. We had the retired traffic homicide guy that came in, that the state tried to make him look foolish. The man who dedicated his life to law enforcement, dedicated his life to investigating crimes and solving murders, who said, I would never charge somebody without evidence, putting him in the seat. I wouldn't charge anybody without proving they're impaired. What did he do? Well, he went and inspected the car. He got in the car. He's 6'3" and got in that car. What did he find? He found a broken rear view mirror. What did Davidson? Did she find a rear view mirror broken? No. Did Bragg? No. Did Revel? No. As far as we know, Pfeiffer didn't even see the broken. We had to show him the picture. Ask yourself, why is that important? Because if there's a crash in a car, if it's outside or inside water, people are going to get injured. And if you don't know who the driver is, and you want to prove beyond a reasonable doubt who that driver is, you do an investigation. Who had injuries? Jordan Nedeau. Where was that injury? Her forehead and to her right eye. Her own doctor, the medical examiner, her right eye could have hit something. If she's in the passenger seat, her right eye didn't hit that rear view mirror. If she's in the driver's seat sitting up, and that car hits that water and she hits up, she hits that right eye on the rear view mirror. Ignore that. Because he owned the car, he was seen earlier driving, and he had made a party with some of these people. That makes him the driver. Well, how did he get out? Their own witness, McLeod. Who had the hardest time getting out of that vehicle? The driver. Why is that? Door won't close, can't latch it when it goes in water. He was lodged against a tree, and the window was 3/4 up. Who had the easiest chance of getting out? Anybody out those windows? How do you think that Mr. Rushing got out through the window? That's their own witness. They want you to believe that a man, Mr. Rushing, who by their own witness, Mr. Degg, if you recall Mr. Degg, he was the man who kind of led this whole thing because he lost his keys. And because he didn't want his girlfriend who's pregnant not to see him in the car with a beautiful young lady. Says park block away or 200, 300 feet away from my house so my pregnant girlfriend won't see me in the car with a beautiful girl. She was a beautiful girl. He didn't see where they went. He didn't know where they went. He turned around and had his own issues to deal with at home. And he wasn't looking back and he wasn't admitting anything. But what did he say? He said he was there. He said they ate some chicken. He said he may have used some weed. And he said when my client drove him, he was fine. He wasn't impaired. He didn't brag. The curious thing that is funny is that they want you to believe Mr. Degg's testimony and put him in the car. But they forget and they haven't even realized that the directions Mr. Dagg said they went to his home are completely different than what my rambling client said to the police that night. They didn't even go the direction that Mr. Dagg said they went. Is that another deception contrived by my client to find some weasel way out of this? Or is it because my client has suffered a traumatic event, may have been hit on the head, may have had alcohol and some of these things, but doesn't recall? Did not recall, and maybe he did suffer a blackout. Not a pass out, a blackout. Blackout is not some phase you're walking around blacked out. It's inability to encode, to remember events that occurred. So none of these, Cecilia Davidson's not going to know if he suffered a blackout. It's not an active thing that you can visually show. It's your inability to remember what happened. So when he's at the police station, he's there reporting his car missing, trying to find Jordan. He's found in a ditch. And we don't know the route he took. We don't know how he got into that ditch, but we know he got in the ditch. We know he got out of the vehicle. But what we don't know is what happened. What happened? Where did they go after Mr. Dagg ran home to his girlfriend, pregnant girlfriend? What happened? Who really knows? You want to rely on my client who can't remember? He couldn't remember what water they were in. He had to be told by a pizza neighbor who said, oh, that's Tower Road. And they drove him out there 2 or 3 times. And then he's seen the road in the daylight. And as Dr. Pritchard, who's an expert in this field, said, sure, when you have a fragmentary blackout, as you see things or hear things, your memory starts to pick up, and then he realized maybe remembering that road. That road, shocking that the case was assigned to a traffic homicide guy, but yet this violent crime guy, Mr. Rebel, this week, or late last week, drives out to Tower Road and takes pictures of road signs and tells you that they were there in 2014. They weren't even there. Why? We know why. It's called the scramble. The state introduced exhibit number 36, which has no relevance to the trial whatsoever, except it will show what a dangerous road this was. Oh, okay. Thank you. You see this? The curious part about this new sign is, look at its location, okay? Look how close it is to the road now. And then look at the next part, it says 500 feet ahead. That gives you a description that the dead end is 500 feet ahead. That's fair. Probably could add water, but I don't know, there must be tight budget. But let's show you what it was like on the night in question. Wow. I don't even know if that's a legal sign. Looks like a private person sign that says dead end. It's got to be 20 feet off the road in the bushes. It's summertime, vegetation could have been half covered up. We don't know when this picture was taken. And look, no 500 feet, is there? It doesn't tell you, all it says is the dead end. That is evidence. This is not. The cracked windshield We introduced photos of the cracked windshield. Didn't make it up. That's a crime scene. That's evidence. That's what this verdict should be based on. Evidence. Who cracked the windshield? Well, you saw my client was seen by Officer Bragg. Any injuries? No. If he hit his head and was bleeding, that would have been seen. Clearly, it would have been visible. He said when he came upon my client, he was disoriented, fidgety, no deception, no odor of alcohol. He wanted to know if his car had been towed. Interesting. He was disoriented a tad bit. Now, he wasn't a marksman act, because if you're drunk and a danger to yourself or others, they can arrest you. He didn't do that. He didn't let him walk home because he was so disoriented that he was a danger to himself. So what did he do? He did the unusual thing and called his supervisor at 9:30 and said, hey, can I give this disoriented guy who's confused a ride home because he's walking down the road? Is that deception, confusion, making up or is that actually what happened? And Dr. Pritchard said he was just in a traumatic event. Car goes underwater. He gets out. He's hit his head, possibly. He sees his friend in there. He can't get her out. He gets out, he's exhausted, and he has a black eye. He passed out, but when he woke up, he was suffering a blackout. They're two different things. So when he came upon that officer, he couldn't remember Jordan in the car and the car where it was. Naturally, he didn't tell the officer. He gets back and sees Skylar. Walks in and says, where's my car? Where's Jordan? And starts crying, doesn't know. That is when someone says, where were you all? And they go out a road and they go, oh, it's got to be Tower Road. They're now trying to help him encode what it was. And that is the first time that they call memory assist is being done. When he walks into Skylar's house, people that were there start to try to tell him, piece together these snippets of what happened the night before. Who knows what else they were telling him? They're probably going back saying, you did this, that, and that. And that's encoding in his memory. How does he know what is true and what's not true? So I asked Dr. Pritchard, could he get information wrong? Sure. So did he know at that point that he was in Tower Road and she was at the bottom of the lake? The evidence is no. So what do? They call hospitals. They try to find out where the car is 2 times. They go down to the landing. First time he says, not sure this is it. Doesn't have the recall the first time. They don't see the car in the river. They go back. And apparently then they make some more phone calls, and then they decide, or he decides, contacts his mom, and then they go to the police station on his own. Mom didn't get a lawyer, didn't say, hey, what you did is so, we better get a lawyer, don't make a statement. No. Mother, father, grandfather, go to the police station. They go to the duty station, put a missing persons out, put a missing vehicle out. And while they're there, they meet Miss Davidson. Relatively young, relatively inexperienced patrol officer, friendly enough, but says he wasn't making sense, he was a bit confused. Of course, she's not going to recognize if he suffered a blackout. She had never encountered this guy. She didn't even know what happened the night before. She's looking for a car. But she's not going to spend resources if they can't get more information. So he gives a written statement, and it's curious, the written statement, inside the statement himself, again, that he gives, he can't recall. He writes in the statement, I don't remember. Oh, I'm sorry. I have very little recollection in his written statement. And this is at 9:30, 10:30. I have very little recollection. But yet the state wants you to believe, oh, you should believe everything he says, even though he says he doesn't have recollection. or whatever he says that benefits him, disregard. Anything that possibly hurts him, you can believe that, and that we don't need to do an investigation. It doesn't work that way. We don't convict people going to the police station and say. People say all kinds of things when they go in there, but it's not true. People believe the mind is a wonderful thing and sometimes can be an awful thing. People believe and feel they see things or have done things they really haven't done. So that's why we rely on evidence, an investigation, law enforcement that's trained, traffic homicide people that are supposed to be specifically trained to investigate, document, bring in evidence. And it was really puzzling because she wasn't really involved in the whole case. And then she got off duty, and then someone called her while she's off duty on her personal phone to tell her that the window on the driver's side is off. And why is that important? It's contrary to him being a driver, contrary to his statement, contrary to their little pattern. He did mention that what facts are important. Air conditioning. He always rides with his windows down. His mother testified to that. He said that multiple times. Always rides with no AC, and it's August. Everyone knows, common sense, August, it's hot. Hot. Skylar comes in, admits that she was out of it, that she went to bed. Really never saw him drinking. There's a photo of a full bottle of whatever you want to call it, alcohol. If we assume it's alcohol, again, we're making assumptions. It's in a bottle, wasn't opened, wasn't tested. They didn't bring you the empty bottle. They showed him holding up a full bottle. He couldn't recall what happened with Davis. And he couldn't recall with Skylar. So as the time is going by, they're going to have you, he's completely making this up, and he's so deceptive that he's able to fake and not remember some things and remember others, but he's keeping this going on at the same time he's trying to figure out. At the same time, he's trying to figure out why his windows were up. Even Pritchard, when he talked to him later, said, I can't rectify why the windows were down if I was driving. That wouldn't be accurate. Fletcher Vaughn. Fletcher Vaughn came in and basically said he was a drunk, he partied, he passed out, and can't recall anything else, doesn't remember anything else, and he didn't take marijuana, can't testify about my client's impairment at 7 a.m. Skylar cannot testify about my client's impairment at 7 a.m. She wasn't in the car. She wasn't around. She didn't see him driving. So we still have two witnesses that can't testify to any impairment. Unless you want to guess and say, okay, if the guy had some drinks, he had to be stoned, he had to be high, and he must have been impaired. That's not the standard we have here. Ryan Deggs, he testified that he drove fine. He contradicts the impairment argument by the state, contradicts the impairment argument by, well, I would say witnesses, but there are no witnesses that said he was impaired when he was driving, if he was driving. And we still don't really know where they went after Deggs. We don't know if they actually went and got the cigarettes. We don't know if they turned down another road. We don't know if they switched places and Jordan got in the car, and that's why she rolled the windows up 3/4 of the way. We don't know that. And the evidence is going to be proof beyond a reasonable doubt by conflict in the evidence, lack of evidence. Deputy McLeod, I think, was a good witness for the defense and a good witness to Mr. Rushing because he said he has never, ever seen a car door, once it goes in water, once it's open, shut and be completely latched. The pressure is too much. You cannot completely close it. I defer to his expertise because he's on the dive team. He's probably uncovered lots of vehicles in the water. This car, the door was completely latched, completely closed, and not half open. No one exited through the door. He indicated that he did see windshield damage. He didn't know what caused it, but he noticed the windshield damage. Not from the outside, from the inside. And he said they pulled it up and he took some pictures. Now, the water was awful murky, and he tried to say she was not in the driver's seat, her body was in the passenger seat. But then upon cross-examination, I asked him, well, when the water is going out that window, wouldn't that push her towards the passenger seat? And he said, yes, it would. So more likely than not, she would probably be more left than she was more right. But the problem we have, internal compartment of the vehicle was never really inspected. No contents have been introduced in this case, except they introduced, appeared to be a billfold in the back seat of Mr. Rushing. We don't know how the vehicle left the river there, Ocklackney River on Tower Road. We don't know where it's been stored. We don't know the condition. We don't know if it was dried out. We don't know if any witnesses or any techs tried to go in there, any CSI, to try to get any DNA. We know that Mr. Crawford went in there, saw some things and he's testified. He may be a little older, maybe a little more experienced, but that doesn't negate his experience. You don't need a college degree, some fancy titles and big bills to know how to conduct an accident crash scene. I think he was candid, I think he was honest, and I think he's got more experience than all of us put together doing a crash investigation. He went in there. He said you could possibly get DNA, you could possibly get fibers once the car is dry. And if somebody hit the rear view mirror, you could possibly get hair fragments and blood. We don't need that evidence. He owned the car, he was earlier seen driving, and he made some statements. Why bother with evidence? Even if her injuries are consistent with hitting her head in that location on that side, and her body is found on that side, and she didn't get out of the vehicle because that's the only window that's up, just ignore that. He had to be driving. This is a guy, in his interview, can't recall whether he had sex with her that night. Not that I recall, I don't think so. I think he would remember that, if he did. But when he says, I can't recall that, he probably can't recall much. So we really don't know if the track seating is actually in the same position that it was at the time of impact. We don't know that. Mr. Pfeiffer. Interesting, Mr. Pfeiffer. He gets retained and listed as an expert. I think he was retained in March or April. Says he did 10 hours. Went to the crash scene June 16th, I think he said it was. So from August 2014 to June 2015, we have no information, no evidence about the car, where it was stored, the condition, who went in it, who went out it. We don't have any evidence. So all of his test results is flawed because there's not a complete linkage, a chain. Normally, a custodian says, this is what I did. I did it here, then I did it here. I collected this. Nobody touched the car. Nobody went in the car. We don't have that. We know 10 months later, this guy with this kinematics, which is fancy for a measuring tape, measured, and then he did his measurements. He really didn't do much investigation. He relied on some figures that were wrong. He had my client at 5'8" in his original test. My client was 5'6". He found that out Monday. The victim was a little taller than what he thought, maybe a half an inch, 5.5. I thought I heard Flanagan say that her leg, hip to leg, was 35. I'll refer to your notes, but I thought she said 35. And I know that he said that my client's hip to ball foot was 35 also. Exactly the same. Asked about arm length. We don't need to consider that. Mr. Commissar cross-examined him, and I felt bad for Mr. Pfeiffer after a while, because the more questions you asked, the less answers you got. And it got to a point like every time he didn't have a figure or he didn't have his measurement, it wasn't going to change his position. It wasn't going to alter his experiment, even though we know that we don't all sit and drive the same pattern. Some people like to have their on 10 and 2. Some people like to do the one wheel. We have people that try to drive low. We got people that sit up. We got people that sit back. And some people tilt the wheel. The tilting of the wheel is the real thing. You tilt the wheel and it puts you all the way towards who the potential driver can be. Some people tilt the wheel so they don't get to move the seat. Some people don't know how to move seats in these cars these days. They're fancy, hard to find. Valet people move cars all the time. And they don't move the seats. If they do, then somehow magically the seat's in the same position was when I dropped it off. So Pfeiffer got paid $10,000 approximately, or he's going to get about $10,000. He brings these two people in, and when he put the two people side by side, the one guy's legs hanging out the car. It's kind of reminded me of when I went to the fair many times, and the guy climbs that little rope, and he makes it look so easy, and he gets you to do it, and then next thing you know, it looks a lot easier than it is. It looks like it's so simple, his test, but in reality, it's not. It's flawed. So all these investigators said they were in a different unit. Bill Revel said he basically, all he did was, well, one, he introduced the wrong sign, and he took statements. I asked him, why didn't you, he voluntarily came in at 7 o'clock, why didn't you take a urine or blood sample? I don't know. Couldn't think about it. Okay, the body was found 11. Why didn't you take a blood sample or urine sample? I don't know. I'm an investigator. It's what I'm trained to do. It's what I get paid to do. 2:45 or something, then they finally get around to it. And now they want to penalize my client by saying, we failed to conduct any investigation, we failed to collect any evidence, but you know what? It was probably there, so we're going to call somebody to come in and say, it probably was there, but it's not. Alcohol is not there. Cocaine is not there. Xanax, even if it is there, it's basically not there. And the marijuana, we don't know when it got there because of the life before or after. We know she's impaired. She has cocaine, Xanax, marijuana, and a 0.17 alcohol content in her. He has nothing scientifically to prove that he's intoxicated. There's not one law enforcement officer to come in and say he was appeared intoxicated. So what do? Ignore it? Just believe their theory? Believe what he said? Believe these drunk people who were intoxicated, high, doing drugs? Just believe them. That's the element. I don't think the jury instruction is going to say that you can believe the impairment based on other impaired people. That's probably not a good measurement. They jump to conclusions and want you to believe it's his car, Dagg's house, he made these admissions on and off, somewhat, wasn't driving. That's enough. We've done it. Finish. He's guilty. All the elements are satisfied. Don't look here. Ignore this, ignore that. Iver did no test on injuries. He didn't look at the head of the woman. He didn't say, okay, the rear view mirror. He went to the scene. He did accident reconstruction, never in a submerged case. Tried to make a big deal about that. But he didn't say anything about, okay, what broke the mirror? He did admit, the closer you are to the steering wheel, less likely you will get steering wheel injuries in a crash. Because you don't have that. You have the, and if you're holding on. No one checked Mr. Rushing for steering wheel injuries. If he's driving that car and it's so back and he's sitting back there and he hits, where's his injuries? He's at the police station at 9 in the morning. He's back at 4. He's there till 11. Take his shirt off. Where's his head injury from hitting the rearview mirror? Bill Rebel said he was confused, disoriented. Didn't know what a blackout was, not familiar with it, wouldn't recognize it if he was under it. Absolutely agree with all that. I don't recall. He said, I don't recall many times. He mentioned the windows and he mentioned the AC problem. Didn't work. He says he wasn't drinking at the club. My client told him he wasn't drinking at the club. Some of these other witnesses, oh yeah, he's drinking at the club. Which is it? And I explained to you, and I'll look at your notes. Look at your notes if you have notes. You don't have to take notes, but ask yourself and look and see what Degg said, how they got to his house. See if it's anywhere near consistent with what my client allegedly said in his rambling statements. So, why the contradictions? Maybe because he's trying to figure out in his own mind what happened. Maybe when he's sitting with the police, he's trying to figure out, piece together these snippets of information that people have given him. Where he was, what he did, what body of water. Maybe that's what he's recalling in this interview. And it's not coming together. Doesn't know how he got out of a vehicle. If you're going to make up, I wasn't driving, she was driving, or if you're going to deceive them in any way, wouldn't you just say, I climbed up, I swam out the window? Why wouldn't you say, oh, she was definitely driving, if you were going to make stuff up? Or maybe he's telling the truth and he doesn't recall. He told Pritchard, Dr. Pritchard in his interview, he couldn't recall. He thought he might have been driving, maybe he wasn't driving. And then I asked Pritchard about maybe survivor's guilt or hero's guilt. Maybe I didn't say survivor. Maybe I asked about hero, he wanted to be a hero. And maybe he's feeling guilty about what happened and feels bad about it, so he's taking responsibility. But the facts just don't fit together. If you really dissect it and you really want to look at this case, and the evidence, the facts don't fit. If you want to just go by his ramblings and say, oh, he admitted it, well, everybody's wasting their time. But how do you, the juror, fit that with the evidence which tells you he wasn't driving? How do you do that? I'm glad I don't got to do it. Independent corroboration, law enforcement corroboration, scientific evidence, we don't have. None of that. Dr. Flanagan, I think her basic job is to determine how people die. And that's a good thing. That's a really tough job. That's a horrible job. I would never want that job. Thank God she's doing it. And she didn't go out to the crime scene. She's not an accident reconstructionist. Her job, she's a medical doctor. I'd ask her, I'm sure she hadn't been in any seminars. She is doing what you expect her to do. Look for injuries to the body, figure out the cause of death, and then try to figure out if she can medically fit the facts to the car scene. She couldn't. She couldn't tell you. She's not sure. The injury her right eye could have been hitting something. That's her words. She could have been driving, possibly. She could have been a passenger, possibly. Could she have wrecked that car without having chest? Could have. We know she wasn't wearing a seatbelt because there would have been that. And even Pfeiffer said if she's real close, she wouldn't have those chest burns. But the scalpel injury and the head injury are the puzzling thing, because when that car went in, it's not like it hit a wall. Okay? Crawford will tell you, when that car hits water, it kind of goes up. And that one's going to go up. It's not like hitting a wall when you go forward. And he clearly said her head did not hit the dashboard unless she was in the back seat and the car goes forward. And there was no evidence of any damage to anything to the dashboard on the passenger side. That's coming from the only person who went in the car and has years of experience, volumes of cases and experience. He didn't take great weight in the location of the seat, because anybody getting in that car can drive that vehicle. You don't have to move the seat. Now, if you're going to drive to Miami, if you're going to drive for a couple hours, or you're going to adjust it and adjust the rear view mirror. But if you're just going somewhere and you switch places and you're going a short distance, you're driving. You jump in there and you're driving. You manipulate your body to the car. And he doesn't rely on that because he's got experience. And he knows. And so what he looked at was the injuries. He looked at that and found, and he gave you a reason why. He told you why that cracked. He told you why the crack spread. He told you where it was. That's what he told you. He told you that car wasn't going very fast. Because why? There's no front end damage. Not much damage to that front end. There's hardly any damage. He believed the damage to the right front was pulling, dragging it out. Our expert testified to that. Not based on some drunk kids or rambling statements by someone who suffered a traumatic event. Who is more likely to drive in the lake? Someone with a .017 blood alcohol? Or someone that we don't even know what his level of impairment was? Driving a vehicle that she's not used to, driving it in a car where the seat may not be adjusted perfectly, and who may not have been able to get out because she was in the driver's seat, and whose body was found in the driver's seat. He's pounding on the driver's window. Why is he pounding on the driver's window? Because she's in the driver's seat. If she's in the passenger seat, he doesn't need to pound on the driver's window. So, if you want to believe all of his statements, you have to believe all of them, not some of them. You can't have it both ways. Flanagan said that she died from drowning. She did not die from the car accident. You want to believe what he's saying, she was still alive after the car accident. Her testimony, scientific testimony, was she died from drowning. Water in the lungs. I submit to you, she did not drown because of that. State would have you believe she's just sitting there impaired in the passenger seat with the window down, and she did not get out of the vehicle. The window's down, she weighs 100 pounds, relatively small, could have easily gotten out of the window, but for her own voluntary impairment. And the government's theory, or the state's theory, would be then that my client climbed over her or climbed and swam in the back seat and swam out a window to get out of the vehicle, since their own expert, McLeod, said the door could not have been closed. How else did he get out? He had to go out a window. Much easier if he's sitting in the passenger seat, get out the window. We go back to, if you listen to his rambling statements and his trying to refresh what he did the night before, and if he did really all the things he said, there would have been some drugs in his system. There would have been some alcohol in his system. If he really drank 14 beers, 2 shots, cocaine, there would have been something in that system. The system doesn't lie. It didn't lie in Jordan's case. It showed what was in her system. Dr. Pritchard is a very serious man, very serious witness. He doesn't add, subtract. He tells you what he thought. He answered your questions, answered my questions, answered the state's questions. He's been studying the mind, alcohol, trauma, and he knows what a blackout is. And we tried to get him to explain what a fragmentary blackout is, inability to recall. It's not made up. It's not junk science. And I wasn't at the scene. I wasn't there with him when he came out of the water and pretend like you don't remember what happened. No, there's no evidence he talked to any lawyer before he went to the police station. There's no evidence he ever talked to any legal counsel. He went down there voluntarily trying to figure out what happened. He was trying to recall what happened. And he said, Pritchard, he may have gotten it wrong. Some may have been wrong, some may have been right. So what do you do with that? How do you parse out what's right and what's wrong? Is that beyond a reasonable doubt? Is that the standard the court read to you? The presumption stays with the defendant every stage, unless it's overcome by evidence to the exclusion of every reasonable doubt. Is there doubt who was driving the car? Absolutely there's doubt. We got 2 or 3 witnesses that says she's driving. Was he impaired? We still don't know. We'd be guessing. Is that road dangerous? McLeod said he's pulled 3 cars out of there. You saw the signs. Dead end. Dead end to what? At nighttime? Dead end? Shh. Right in the water. No evidence of speeding. Nothing at all. No evidence of driving erratic at all. I told you this was a difficult case, and it is a mystery, because when you look at the evidence, you listen to the experts, you look at the science, we don't know who was driving. The state wants you to say, oh, he's driving, he said he was driving, he had to be driving, he had to be driving, he was driving earlier. He's got no injuries, no one puts behind the wheel, no one knows where they really went, he gets out, she doesn't, she has injuries, he doesn't, and the injuries are consistent with who was driving the vehicle. She's found in the driver's seat. He gets out of the car. Tom Crawford, Florida Highway Patrolman. We love Florida Highway Patrol. If I can't put him in the seat, and I can't make him the driver, and if I can't prove he's impaired, I'm not going to arrest him. It would come back on me. 37 years experience. He supervised every traffic homicide for FHP for the last 14 years. He himself was a lead investigator on 360 fatalities. 360 too many. This was not a violent crash. In her closing, prosecuting, this was a violent crash. Violent crash would deploy the airbags. This was us, right into the water. Air flags did not deploy. There was no damage to the front end of the vehicle. The only damage was the rearview mirror inside the vehicle. The mother testified that that crack was not in the windshield. Mother testified that he always drove with the windows down. That's a fact you need to look into and say, how does that fit? How does that fit in this little puzzle? If you're going to look at the puzzle, if you're going to put the puzzle together, or if you're just going to go in there and say, well, they said it, he must have done it, he's here. That's not what we do in our country. That's not what we do. And that's not what you said you do when you took the oath. You were going to base it on the evidence. Now, you don't have to accept all the evidence. Judge is going to tell you the evidence, and he read the instruction. Conflict in the evidence or lack of the evidence. That's the problem with this case. There's a conflict in the evidence, scientific evidence, and there's a lack of evidence to prove he was driving and driving impaired and caused her death. Clearly, there was no reckless driving. Count two, there's absolutely nothing to suggest that he was driving in a reckless manner on a dangerous road at night and the vehicle basically just went going straight. Count three, leaving the scene of a crash involving death. Now, the interesting thing is, on that count, in element 2, you're going to hear Jeffrey Rushing knew he was involved in a crash and had a duty to report it to the police. Not what he knew, not what he knows now, not what he knew later, but when at the time of the crash, what did he know? And all the evidence suggests, from Bragg to Davidson to Schuyler, he didn't know. He didn't know where his car was. He didn't know what Jordan was. All he could recall was water. He voluntarily went to the police station on his own. He voluntarily stayed at the police station on his own. He's picked up and given a courtesy ride because he's so disoriented. Is that knowing, and did he have an obligation if he didn't know at the time he got out, when he was first had contact with the police? I suggest to you, it's not. It's consistent with what Pritchard said. He suffered a blackout at that moment, didn't realize what really happened, and it was a traumatic event. Willfully means knowingly, intentionally, and purposefully. In regards to his statement, the judge read you instructions on how to take his statement. Once again, on page 8 of your instructions, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. Knowingly suggests he had full capacity, all of his resources, understood, was able with clarity to know what he was saying. I suggest to you that Pritchard reviewed his statements, Pritchard interviewed him, Pritchard said he was suffering from a fragmentary blackout. And Pritchard said it's hard to figure out what to believe or what not to believe. I suggest to you, ladies and gentlemen, what you should believe and what you should rely your verdict on is the evidence. What physical scientific evidence has been introduced. And I submit to you that they have not proven beyond a reasonable doubt that he was the driver. They have not proven he was impaired. They certainly haven't proven that if he was driving, he did it in a reckless manner with the intent to kill her or harm her. Call him straight in the water. And they haven't proven that when he got out, after being passed out from that traumatic event, that he wasn't suffering from a blackout and that he knew he was in a crash. He is a young person. The young lady in the car was a young person. It's not an easy case for anyone. But we require proof beyond a reasonable doubt. Beyond a reasonable doubt. Ladies and gentlemen, we can't bring the young lady back. But you can't penalize him because law enforcement failed to do any investigation, failed to collect evidence that would have exonerated him, and just say he owned the car, he was earlier seen driving, and he made these statements. That's not enough. It's in conflict with all the other evidence. You're going to do the right thing because it's not easy. But as long as you base your verdict on all the evidence, not just statements, but on the evidence, you're going to have to find him not guilty. And that's going to be hard to do. But that's what your oath is for, on the evidence. Thank you, Your Honor.
Rebuttal argument from the state.
Yes, Your Honor.
What did I press? I don't know.
Did he say 2 to 3 witnesses said she was driving? What we say is not evidence as lawyers, and the judge will give you an instruction about that. So what Mr. Jansen says is the evidence. That's your decision. We each tell you what we think it is. What Mr. Jansen says about what usually happens in other trials, that's not in evidence. Focus on what's before you. And you make the decision, is it enough? Oh, we only have him driving the car and admitting that he was driving the car, and we only have him admitting he was drunk and other people seen him drunk. That's not enough. Well, that's your decision to make. Reasonable doubt, when you're deciding your verdict back in the jury room, reasonable doubt is not just a possibility or a speculation. If you're back there saying, well, it could have been this a whole other thing that there isn't any evidence of, but it could have been, that's not a reasonable doubt. You have to be able to attach a reason to it. It's not anything that's possible, anything that's speculative, or anything, that you could come up with. All these wild, possibilities we've been talking about. Counsel said something really interesting in opening statement, which I wrote down. I don't remember if y'all remember. But he said the mystery bit, and then he said, the driver of the vehicle is the one that's responsible. And he went on to say, there's not going to be any evidence that my client was the driver. But I do agree with him that the driver of that vehicle is the one that's responsible. But aren't we saying something else now in closing argument? Didn't we just hear that lots of other people and other targets are responsible? The cops are responsible. They did a terrible job. The county sign people are responsible. They didn't put up a good enough sign. The witnesses are responsible. They're all drunk and high. You can't believe them. Well, they're his client's friends. They're not, I didn't pick them. They didn't say he was drunk. Well, I disagree. You rely on your memories of the evidence. My recollection is that Skylar said they were drunk in the kitchen. Fletcher Vaughn said that they were drunk and had a conversation at the bar about, I drank more than I should have and smoked. Maybe a blackout is to blame, not the driver. Maybe an expert is to blame. Dr. Pfeiffer charges too much. He doesn't know what he's talking about. He's only got a PhD in engineering. He's fancy. But our expert, you should believe, Mr. Crawford, I'm not going to talk about Mr. Crawford. And I was not trying to humiliate him, but this is a court. If you're going to say something, have a reason, have something to back it up. Dr. Flanagan, you can't trust her opinion because she's not an accident reconstructionist. Well, no, she's not. She's a medical examiner who's done, what did she say, thousands of autopsies. So she knows what injuries are. She investigates death. She determines causes of death, not just medical stuff, but forensic stuff. She works on criminal cases and makes determinations about how people die. And her opinion was that the victim was on the passenger side when that crash occurred. And finally, aren't we blaming the victim? She was the real culprit. She's the driver. Well, unfortunately, she is not here to tell you what happened to her that night, but the evidence in this case speaks for her. She was on drugs. Well, yeah, she sure was. And it's interesting that everything in her system is the same stuff that he says he was on that night. And that's like taking a snapshot of what they were up to, because when she died in that vehicle, her body didn't process those substances anymore. And it gives you a clue. I mean, not necessarily they took exactly the same thing, but it is interesting that she's got cannabis, Xanax, cocaine, and alcohol. About double what the legal limit would be of alcohol to drive. But she's not on trial, folks. She's not to blame. So we've got all these other targets or diversions that the defense is talking about in closing argument, but none of these things are to blame. None of these things get it right. You know, what got it right was opening statement. The driver of the vehicle is the one that is responsible. And he even said something in closing that I agreed with. He said, this was a beautiful young lady. Well, she sure was. Just absolutely so full of life she could jump off this page. And due to the actions of this defendant and his choices that he made that night, and that's what this case is about, him, this is what became of her. As she gasped for air in that vehicle and drowned alone and scared in the dark. And there's only one person responsible for that. One person's choices that led to that. She didn't kill herself. The crash killed her. She drowned because the crash was in a body of water. He is responsible for his actions. In the event that you get back there and you think you might have a reasonable doubt, please listen to the statements again, because he does dig his own grave with those statements. That's why the defense is working so hard to get you to not listen to them. Statements like multiple statements about being on the driver's side and never going over to the passenger side. Statements like defendant rushing. I'm almost 100% positive. Well, he's asked, and you're sure it was Tower Road? Answer, I'm almost 100% positive. I'd give it like 98. If it's not that, it's an extremely similar setup, and they were telling us about the only thing like that out there. Detective Revel, what do you remember from last night other than the dirt road? Do you remember any other landmarks, any parks, any buildings? Answer, yes, sir. I remember I knew I was on Tower Road because it was Benson Heating and Air. I specifically remember. So that's how I knew I was on the right road. And statements like this. Detective Revel, well, was she intoxicated? We all were, everybody. Detective Revel, too intoxicated to drive? Why didn't she drive? Why did you drive? Defendant Rushing, she didn't drive because she's smart, and I drove because I'm a dummy. That's all there is to it. You were too drunk to drive? Well, any drunk is too drunk to drive. Don't ignore those statements. Don't ignore the other evidence in the case. Look at all of it and render a verdict that speaks the truth. There is no mystery here, folks. It took a long time to get there, but it's not a mystery. There is only one verdict that speaks the truth in this case. There is only one verdict that will do justice for this beautiful young lady, and that is a verdict of guilty as charged. Please find him guilty. Thank you.
And thank you to both counsel. Members of the jury, if you're reading along with me on the jury instructions on page 9, on the section that talks about rules for deliberation. And there are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. First of all, you must follow the law set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There's no reason for failing to follow the law in this case, and all of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of witnesses and have seen in the form of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone, nor should your verdict be influenced by feelings of prejudice, bias, or sympathy. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's duty to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous, that is, each juror must agree to the same verdict. In just a few moments, you'll be taken back again to the jury room by the bailiff, and the first thing you should do is select a foreperson who will preside over your deliberations like the chairperson of a meeting and will sign and date the verdict form when all of you have agreed on the verdict in the case. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Only one verdict may be returned as to each crime, and it must be in writing, so for your convenience we printed up the verdict forms for you, which will go back. They're fairly straightforward. You'll see, as I mentioned, they're called counts, so you'll see count 1, count 2, and count 3. And there will be your options all the way from guilty as charged down to if there are any lessers, they'll be underneath that in terms of their priority, in terms of how serious they are, I guess. And the last option on each page will be not guilty. And as to each one of those choices, there's a separate place there to sign and date as the foreperson. So, in closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case, and even if you don't like those laws, you must use them. For 2 centuries, we have agreed to a constitution and to live by the law. No one of us has the right to violate the rules we all share. And finally, deciding the verdict is exclusively your job. I cannot participate in that decision in any way, so I ask that you please disregard anything I may have said or done during the course of the trial to make you think I preferred one verdict over the other. So with that, I will let you go back with the bailiff, and we will await your instructions. The exhibits that have been introduced in trial, including the videos that you saw, will be available to you. And if you need some assistance, let the bailiff know, and we'll try to provide it for you. So lawyers, if y'all get with the clerk, make sure we've got all the exhibits and nothing we shouldn't have to go back to the jury. Right. Unless it was introduced as an exhibit.
We need to clear out.
We're going to ask y'all to move your stuff out of the way, and I'll get started on another case. Okay.
Should